She left him after a domestic violence incident where he strangled her. After that, he was calling. I promise I will effing make sure that this baby does not make it to this earth. I think with the facts that I've heard, with the nature of the charges and everything else, if necessary, I mean, I'll just make the finding. I think it's an absolute abuse of discretion that the bond got set where it is.
What you just witnessed, the strangulation allegations, the chilling threats to an unborn child, and a judge's visible shock are only the breaking point. But what exactly led a man to this level of desperation? This is the case of Timothy Stevens. It's really a battle for a pregnant woman's survival. Why did Stevens drive an hour to stalk her home? His defense claims he's seeking mental health help, yet his own texts brag about catching charges and breaking her skull. If he's truly seeking treatment, why is he sending videos of himself speeding at 100 miles an hour? With a low bond, her life is on the line. If you want to understand courtroom psychology and see how judges spot these dangerous patterns before it's too late, hit subscribe. Let's go back to where this all began.
Court calls case People versus Timothy Stevens.
And it was then on behalf of the people. All right, thank you.
Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Stevens, who's approaching. Mr. Stevens, could you state your name for the court?
Timothy Stevens. Thank you.
Your Honor, in this matter, we are requesting that this be set for preliminary examination. There's no offer available at this time. I think the only question I had, and I'm not 100% sure, is the 911 call, but if we don't have it, I feel confident we could get it before and we may have it through on base. I wasn't 100% sure, so.
Sorry,
Okay.
I don't believe there is an actual call.
Okay.
It was a walk-in report, so I don't believe there is.
Okay.
That answers that. So then, to my knowledge, discovery is complete.
People have their witnesses available the 13th.
We'll do our best, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. That is before me.
Your Honor, I would ask to address bond briefly.
Okay.
Mr. Stevens' mother is in the courtroom. We are asking for a 10% provision on his bond. This obviously, the allegations in this case are very serious. However, usually with these types of charges, there's an allegation of a violation of a court order. And this is not one of those cases. So there is no evidence or allegation that Mr. Stevens violated a protective order or a court order prohibiting him from having contact with the complaining witness in this case. So I would argue Mr. Stevens will abide by court order. Now there is a court order obviously prohibiting any sort of contact. Mr. Stevens does not live with the complaining witness. He has his own residence. His mother is here in the front row to support him, to offer her support. He doesn't live with her, but she indicated to me on the phone yesterday she would provide support to him. He also is going to sign a release of information. He reached out for mental health treatment prior to his arrest, but he wasn't really in as intensive treatment as he needs. And everybody, including his mother and himself, acknowledges that he needs mental health treatment and he wants it. And he'll do anger management, he'll do counseling, he'll do therapy, he'll do his medication regimen. He'll also wear a GPS tether to provide additional security.
But I mean, has treatment been set up for him?
So he reached out prior to his arrest. I have not received any paperwork, and I'm hoping he'll sign this ROI so that I could try to verify that he did reach out and complete the first step of the process. So he did give me the specific names of people that I verified work at this organization. So I think that was in the process.
Okay.
It was in the very beginning.
I just wanted to make sure I wasn't clear on that. All right. Yes.
Your Honor, I have a strong objection to any change of bond. We originally requested in this case $100,000 cash surety. I would be reviewing that request at this time. In this case, they dated 8 months. She left him after a domestic violence incident where he strangled her. After that, he was calling, texting her on different platforms. She made it explicitly clear that she wanted no contact with him. He was seen on her home security at her house for an hour, in which he drove from his residence in Romulus to her residence in Saline. So I have great concerns about that he would drive that far of a distance to go to her house on a couple occasions. And then in these messages, I have severe concerns for her safety, his safety, and the community's safety. He was saying things of the nature I promise I will effing make sure that this baby does not make it to this earth. All I effing ask of you is just to talk to me. You can't even do that. You're a effing non-excusable woman. I'm legit going to heaven or jail this weekend, so I'm about to enjoy it. I swear to God on my life, if you have another man in your phone, I will take this too far. He said, you think your door will stop me? Call the cops on me, and you better expect some repercussions. You call the cops on me. I'm coming in your effing house. I might want to answer the effing phone before I drive the F down there and break your effing skull open. I'm not effing playing with you. I'm about to catch some effing charges. And then in these messages, he also sent a video of him with numerous pills threatening to kill himself, and then also a video of him speeding over 100 miles an hour on the road to her. So I have great concerns for his safety, her safety, and the community's safety, and have extreme concerns with this case, and will be asking for our request for $100,000 to be reconsidered on his bond.
What are you?
May I respond, Your Honor?
You may.
So clearly he's in jail. I have not received any allegation of a bond violation. He is held on this bond. So I would argue there's absolutely no reason to increase his bond with there being no bond violation. There's no basis for an increase in his bond at this time. There's no bond violation. He is held in jail. He can't pay his bond as it is. So there's absolutely no reason for a bond increase without a bond violation. Furthermore, he's not charged with assault. I know the messages are very awful, but he's not actually charged with any assault. He's not charged with strangulation. He's not charged with domestic violence, nothing. So his charges are based on these messages and malicious use of telecommunications device, obviously. So I just want that to be clear because obviously I think this would be a different case if he was charged with assault.
And I just want to bring the court's attention. The victim informed officers when she reported that the DV incident, the strangulation, occurred in Romulus. I'm not sure if any charges have come from that in Romulus, but
The
yeah.
DV.
The incident that caused the breakup that led to these texts and calls.
So,
all stem from.
right, but so when was that alleged to have occurred, do you know?
I believe it was late February, early March, is when that incident, she said, occurred in Romulus and his residence.
Council approach. So that occurred in February, March, then these charges arise in April.
Correct.
We don't know if the charges in Romulus have what's happened yet.
If they were trying to, I'm not sure.
My information is that there's no charges based on that.
Part of my concern is that I'm not clear, given those factual allegations, and I realize there's a presumption of innocence, certainly in this case, but given the nature of the charges and what was just relayed to the court, which are sort of at the base of these particular charges, I'm not sure how we got a $5,000 cash surety bond. I don't. I'm having grave trouble with that as to how the bond got set where it is in the first place. Anything else you want to say?
Well, just that I would argue that the court shouldn't increase his bond with no bond violation because it is, it is
But I
resulting
think
in.
that his bond is initially set is absolutely inappropriate just based upon what I've heard here. I mean, I think with the facts that I've heard, with the nature of the charges and everything else, if necessary, I mean, I'll just make the finding. I think it's an absolute abuse of discretion that the bond got set where it is out of the gate. So, I'm going to increase the defendant's bond. I'm going to deny the defendant's bond request. I'm going to grant the people's request that the defendant's bond will be increased. His bond will be increased to 50,000 cash surety. I won't send it up as much as they want it, but I think that where it's set now is absolutely inappropriate. Thank you.
The decision is final. The judge increased Stevens' bond to $50,000, citing a total abuse of discretion in the original ruling. But here's the question. Was this a legally sound move, or should bonds stay the same if no rules were actually broken? Comment below, Team Stevens or Team Victim. Did the judge overstep or do what was necessary? If this case got you thinking, hit like. Share this with anyone who loves real courtroom drama.